Hello and welcome to the In Focus series section of Drishti IAS. I am Aisha Singh, and in today's video we will be talking about the challenge that has been given to the first amendment to the Constitution. That is, the first amendment that was made to the Indian Constitution has recently been challenged, and Supreme Court has agreed to see the petition. So first let us understand the timeline of the video. First we'll be looking at the news, that what is the issue, then about the first amendment to the Constitution, then the constitutional position on free speech, then about the first amendment made, two key challenges or two key changes that the first amendment has made that has been challenged by the petitioner, then what are the petitioner arguments, and then the case that promoted the first amendment. In the end, a prelims MCQ. So this topic is of relevance from General Studies paper 2, that is Indian Constitution. From exam perspective, you should be able to know that what is the first amendment to the Constitution, as whatever if it is first, then it becomes all the more special. So let us see the news, and this has what has happened recently is that Supreme Court has recently agreed to examine a plea that is challenging, and this plea or the petitioner is challenging the first amendment. The first amendment to the Constitution that was made in 1951, the petitioner is challenging on the ground that Article 19, the restrictions present under Article 19 is what the petitioner is challenging. So I'll be telling you about the whole issue, and this news I have picked from Indian Express. And the Supreme Court has agreed to examine a plea which is challenging the expansion of restrictions to the fundamental rights to freedom of speech and expression. And freedom of speech and expression is which fundamental right? I hope you all will be knowing it. It is Article 19, and we all know that Part 3 of the Constitution consists of fundamental rights, and the fundamental rights are not absolute in nature. Every fundamental right has some or the other restrictions to it, and there is only one fundamental right which is absolute in nature. And can you people tell me? That is Article 17, that is untouchability. So that is the only fundamental right which is absolute. Rest all fundamental rights are not absolute in nature, and there are some restrictions which are imposed on these fundamental rights, and these restrictions are considered to be important in some way or the other. So the first amendment to the Constitution has also inserted some restrictions under Article 19, that is freedom of speech and expression. And these restrictions is what the petitioner is challenging. And the petitioner has argued that the amendment is damaging the basic structure of the Constitution. So the petitioner is saying that by including those restrictions, the basic structure of the Constitution is getting damaged. And can you people tell me that from which case the basic structure of the Constitution came into prominence? It was the 𝐾𝐸𝐺𝐸 𝐏𝐵 case. So this is what the petitioner is saying, that the amendment, the first amendment to Article 19 is damaging the basic structure doctrine. So we will be looking into this issue now. So what is the first amendment to the Constitution? So the first amendment was officially came into effect on June 18, 1951. You have to remember the year. Year becomes important. The first amendment came in which year? It was 1951. And the Constitution, which is the first amendment bill, it sought to make several changes, from exempting land reforms. So land reforms from first amendment to the Constitution, which schedule was added? It was the 9th schedule, which talked about the land reforms. From scrutiny to providing protections for backward classes in the Constitution. And the first amendment also expanded the scope of the restrictions on the right to free speech. This third point is what we will be focusing on, that the first amendment expanded on the scope of the restrictions on the right to free speech. The two important word here is expanded. So what does the word expanded means? See, when something is already present, then only you can expand that thing. It means the restrictions was already there, but it was expanded. It became more wider. And the second word is the restrictions. So now we'll be talking about the Article 19 and its restrictions. And the first amendment was passed in 1951 and it amended several other fundamental rights also and several other articles also. But the article which we will be focusing on is Article 19, and all other amended articles include Article 15, 85, 87, 174 and all others. And the first amendment also added 9th schedule to protect the land reforms and other laws included from the judicial review. So this was about the first amendment, and what you have to remember is the first amendment was passed in which year? It was 1951. And the first amendment included which schedule? It was the 9th schedule, and the first amended many other articles also. Now let us talk about the constitutional position on free speech. So it is Article 19 Clause 1 Clause A, which talks about the fundamental right to freedom of speech and expression. And this Article 19 and about the freedom of speech and expression is something which we hear on a daily basis, that the Article 19 consists of freedom of speech and expression, and this freedom is not absolute. As I've already told you that mostly except one, almost all the other fundamental rights has restrictions, and these restrictions are provided in some way or the other. So Article 19 also is not absolute in nature, and Article 19, which is freedom of speech and expression, also has certain restrictions under it. Then Article 19 Clause 2, which list exceptions or reasonable restrictions on that right. See, Article 19 Clause 1 talks about freedom of speech and expression, and Article 19 Clause 2 talks about the restrictions which will be imposed on Article 19 Clause 1. So the freedom of speech and expression also has restrictions, and these restrictions are being talked about in Article 19 Clause 2. Okay, now see this image very carefully. See, this is the first para and this is the second para. I have taken the exact wordings. This is Article 19 Clause 2 in the original Constitution, and while this is the amended one, that is Article 19 Clause 2 amendment. See, this was what was present in the original Constitution, and this, the second paragraph, is the text which was present after the first amendment of the Constitution. So the first amendment of the Constitution amended the article and it inserted few words and it also exempted few words. So I will be telling you about that what the petitioner is challenging, that what it is that is actually disturbing. That is actually disturbing the basic structure of the Constitution which the petitioner is trying to challenge. See, first we will be talking about the original Constitution, the text which is present in the original Constitution. So it says, Article 19 Clause 2 says that nothing in subclause A that shall affect the operation of any existing law in so far as it relates to. I will be telling you what is being changed. Don't think that I will not be telling you, I am just reading. I will be telling you the important words. Or prevent the state from making any law relating to libel, slander, defamation, contempt of court or any other matter which offends against decency or morality or which undermines the security or tends to overthrow the state. So see, this is what is present in the original Constitution, and it says that anything which is defamation, slander, libel, contempt of court or any matter which offend against decency or morality or which undermines the security or which tends to overthrow the state. This is what is present in the original text. Now I will be telling you that the words which was inserted in the constitution after the amendment. So the text remained almost the same, and the words which was included was first the words of reasonable restrictions was included, and then the word public order. Public order is not present in the original constitution text. So the word public order was included in the text, and the incitement to an offense. These two words was not present, or I should say that these two restrictions was not present in the original text, but these two restrictions was present in the constitution after the first amendment. And these two restrictions is, first is public order, which was not present in the original text, and second is the incitement to an offense. So these two restrictions became part of the constitution after the first amendment. That first is public order, second is the incitement to an offense. And the word which was omitted from the original text. See, first I am telling you that the words which was not present in the original text of the constitution and which got inserted from the first amendment, it was public order and incitement to an offense. So these two restrictions was not present in the original text. And something which was present in the original text but was not present in the amendment was which tends to overthrow the state. This line was not present in the amendment, which tends to overthrow the state. So the amendment, the first constitution amendment, included the word public order and incitement to an offense to Article 19 Clause 2. It means two more restrictions was inserted by the first amendment into the Article 19, and these two are the restrictions. Okay, see this. First amendment made two key changes. So the first one was that it introduced the qualification which was reasonable restrictions, and these two qualifications was, first was the word public order and second was the incitement of an offense. And something which was not present in the first amendment was tends to overthrow the state. And now let's talk about what the petitioner is arguing. What are the arguments that the petitioner is putting? So the petitioner is saying that by including words like public order and incitement to, I'll just show you. See, public order and incitement to an offense. So the petitioner is saying that these two words like public order and incitement to an offense is very subjective and can be changed from one scenario to another. So he is saying that this will neglect national security. This will neglect national security, as it neglects national security by dropping the expression tends to overthrow the state. Tends to overthrow the state, the term which was, or the line or the phrase which was present in the original text but was not present in the amendment. Wait, I'll just show you again. You need to get this clear. See, tends to overthrow the state. This sentence, this phrase was present in the original constitution but was not present in the amendment. So this was removed. So the petitioner is saying that this will neglect national security, as dropping the expression tend to overthrow the state, because if state will not be having the power, then the national security will be at risk. And the second argument which the petitioner is putting is objectionable insertions in the interest of public order and in relation to incitement to an offense. So these two restrictions which has been inserted after the first amendment is what the petitioner is saying, that these are objectionable insertions. that is public order and incitement to an offense, as the petitioner is saying that these are subjective in nature and can be changed from one scenario to another. So, national security will be at risk and the objectionable insertions is what is the petitioner arguments. Public order and incitement to an offense. Now let us talk about the case that promoted the First Amendment. So this case happened which actually promoted the First Amendment and it brought the light to First Amendment, and that is Romesh Thapar case. Okay, before starting of the case, let me tell you the few important points from this slide was, first you have to know about the First Amendment. That is the most important thing, that the year of the First Amendment was 1951 and who was the Prime Minister at the time of the First Amendment. Then you have to talk about that the schedule which was added by the First Amendment, then also the articles which was amended, and especially the Article 15 and the Article 19. Then you have to remember that which two insertions took place after the First Amendment, that was public order and incitement of an offense, and which was the term or the phrase which was dropped after the First Amendment, that is overthrowing of the state. So these are the important points that you have to remember. Now let us talk about the Romesh Thapar case. I have written the whole case so that it becomes easy for you. That this case in 1949, what happened was the Madras government banned the Red Roads, and Red Roads was a magazine, and because the Red Roads, the magazine was criticizing the government foreign policy. So it was, the government tried to ban it because they were criticizing the foreign policy. So this led to the first significant free speech ruling by the Supreme Court in Romesh Thapar versus State of Madras. So what happened was that because the government tried to shut the magazine, so this became a point of concern, and the government imposed restrictions for the wider purpose of securing public safety and maintenance of public order. So the government said that if the magazine will go on criticizing the foreign policy of the government, then this will disturb the public safety and the public order. And then the Supreme Court had to define the term public safety and public order, and they examine if they fell within the scope of the restrictions which was allowed in Article 19 Clause 2. So what happened was that the court was seeing whether the word which was used by the government, that is public safety and public order, they actually come under the scope of the restrictions which was present in the Article 19 Clause 2. But if you will remember that this is the case of 1949-1950 and the First Amendment came in which year? It was 1951. So this case is before the amendment. So the government argued that the word undermining the security of the state in Article 19 Clause 2 could be equated with public safety and maintenance of public order. So this is what the government said on its behalf, that why did they try to stop the magazine, so that public safety and public order was maintained. But the court had to see that whether the word public safety and public order actually came under the scope of the restrictions which was present in Article 19 Clause 2 at that point of time. So the government, they argued that the word undermining the security of the state can be equated. This is what the government said at that point of time, that undermining the security of the state can be equated with public safety and maintenance of public order. But what happened was the court disagreed with the government. So at that point of time, the court did not agree with the government and they struck down the provision as unconstitutional. So at that point of time, the government and the court did not agree with each other and they struck the provision as unconstitutional. And this is what led to the First Amendment, that the provisions of public safety or the public order or incitement to an offense should be included. And that is why the First Amendment in 1951 took place. So this was about what is going on and what the petitioner is saying. So in the end, let us do a prelims MCQ, and you people need to tell me the answer in the comment section. And it says, the 9th schedule was introduced in the Constitution of India during the Prime Ministership of, and this was a UPSC PYQ, and this was asked in 2019. And Jawaharlal Nehru, Lal Bahadur Shastri, Indira Gandhi, Morarji Desai. So try to solve this question and tell me the answer in the comment section. So that's all for today. Thank you so much for watching. Till we meet next time, keep reading and keep writing.